Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Oxford University Press. Now don't be put off by the title. This is a high-level book. It's very, very well written. The title is The Criminalization of European Cartel Enforcement. Yes, there's a lot in that, and we'll find out what exactly that means in a minute. It's got a subtitle, Theoretical, Legal and Practical Challenges. So we're looking at the challenges that we're facing with criminalising, making it criminal with the operation of some types of cartel and trying to enforce this whole issue of criminalisation. The book's been written by Peter Whelan, and it's part of a series of books from the Oxford Studies in European Law, an excellent initiative and one that I found very interesting because I recently attended a magnificent seminar looking at the future of criminal law should we exit the European Union at some stage, because in fact that will cause a huge amount of difficulty. But the issues are still there because we are obviously very strongly linked both with Interpol and with the whole range of different national and international organisations that now deal with effectively serious problems that affect individual states on a much wider basis than we've ever really seen before because of the extension of the global community and the fact of the ease with which people can move through one border to another and so forth. Now, we've given the title of this review the following title: Meeting the Challenges of Cartel Enforcement within the European Union, an important contribution to the debate. And that's what it is. And what we'll do is we'll have a look at our review in a minute, but I'm going to show you the book first of all. It's a hardback. Well, it's quite a heavy book. There it is. There's the front cover there. Then there's the spine. Then you can see on the back there are other titles in the series. There's a little bit of blurb about the book itself, setting out exactly what this is all about. Then if we look on the inside dust cover, there's some basic information about the book, and it explains who Peter Whelan is and from the University of Leeds. Then there are other books from OUP on the back, a little bit of plugging for OUP. It's an excellent book, this again. Runs to 350 odd pages. There's a shortish index there, which you can see. There is, of course, a very substantial bibliography, which you can see there. This is academically a very high level, this book. You can see the bibliography itself is actually there. It starts there, and it's actually a very substantial one. There's a huge amount of work and learning that has gone into this. There are, of course, some annexes at the back. There's the text of the original UK cartel offence and Section 47 of the Enterprise and Regulatory Reform Act 2013. Then the text of Article 10 of TEFU, which is there. I'll explain that in a minute for those who are not quite so familiar with it. There is the front of the book, and then the other books in the series itself. It's a nice dedication, which I will show you there. I always like to point those out. Then there's a preface from the series editors, who are Paul Craig and Gronya de Burker. And you've then got a preface there, which is always worth reading because you get some idea of what this is all about. Useful acknowledgements, because this is a detailed statement by Dr. Wheeler. And you've then got the table of contents, and you can see what they've got there with the different parts. An introduction, then theoretical challenges, legal challenges, practical challenges, conclusions, and then the annexes. So there are 11 main chapters in total, then the annexes at the end. Very useful abbreviations. A must now for quite a lot of this stuff, especially within Europe, because there are a lot of abbreviations which one might not be as familiar with. And table of cases. Again, you've got a European cases as well. Note to reader. I've attempted to state the relevant law as at the 1st of January 2014, when the text was completed. It is actually some time ago, so I'm recording this in 2015. But do bear in mind the background to this. And let me show you the structure of the book itself, the content. You see there's the heading, you've got good footnoting, which is there. You've got various parts. When we go into, and you see that's the introductory section, then we go into the first part one, theoretical challenges. potential theoretical justifications for European antitrust criminalisation. So a lot of words here, a lot of detailed content. There's no paragraph numbering as such, but you do have subheads and various subsections throughout. And as I've said, you can see there is extensive footnoting, which does help, mainly because there is such a lot of bibliographical detail at the back. There's the middle of the book. Then we go to the end, the existence of a criminal antitrust offence. Now, of course, there are people who just do not recognise, and I've met them, especially in certain countries in the world, and I'm not going to mention Hong Kong or any of these other places, but there are in fact a number of people who just do not accept that this sort of thing should be anything to do with criminal behaviour. Now, whether that's again perhaps a jurisprudential issue of its own right. However, the fact is that we live in a real world. We are part of the European Union and will be hopefully remaining part of the European Union. In any event, we do have to have agreements about how we conduct our business. And one of the basic agreements, although the courts don't want to get involved in business arrangements because they don't see it necessarily as their particular function, however, there are occasions when the state has to intervene when clearly behaviour is wrong behaviour, and that is when people have unfair advantages over other people, and they have sometimes created very unwieldy organisations with too much power. Again, that's a matter and an issue which, depending on your point of view, is something that should perhaps be a legitimate issue jurisprudentially for crime, or perhaps for some way of dealing with it. We've always had that issue, for instance, with company directors' disqualification. Now, many clients I've come across think, well, it's nothing to do with the criminal justice system. And as you will be aware, generally speaking, it isn't. In fact, you can disqualify a company director because actually the level, the bar for that is balance of probabilities. Whereas, when you're looking at any form of an allegation of fraud, certainly in our jurisdiction in England and Wales, it is beyond a reasonable doubt. So again, you've got a much higher bar being set for proving anything. So you can see that in fact in the civil jurisdiction, it is logical to consider looking at some of these activities in purely the civil sanctioning area, in other words, by means of a disqualification rather than actually locking people up in some form of custody. Now, having said all of that, let's look at the book itself, because the formation of cartels, which is usually created by big corporates, imposes monopolies on otherwise free markets, thus creating unfair competition, or rather no competition at all. That's where the unfairness comes in. With price fixing, which is one of the end results of antitrust activities, companies profit whilst consumers suffer, and that's the basic argument. As most corporate lawyers are aware then, America, with its fierce body of antitrust legislation developed well over a century now, is very strict about such matters, and the European Union less so, at least so far. They are catching up, as you probably will get the message when you read the book, that that's actually what is happening at the moment. The existing and potential sanctions within the European Union designed to deter or punish those who set up cartels form the basis of this rigorous and analytical study by Dr. Peter Whelan, and it's been published by OUP. And as I've indicated, Dr. Whelan is at the University of Leeds. This book is one of the latest titles in the OUP's excellent Oxford Studies in European Law series, an important addition, I think, to the general debate about our relationship with the EU, and something that we now have to do across the board with our legal studies, certainly at undergraduate level, and for older people like me coming into this where the EU really was not as big a player in those days. It is very important for us to keep up to date with changes that are taking place, and this is an area, I think, where there will be big change in the next couple of decades. The series anyway is, and the aim of it is to publish important and original research on EU law, and that's what they do. And I'm very grateful to them for doing that, because it does enhance one's general knowledge apart from anything else. As its title indicates in this one, The book explores the antitrust enforcement landscape within the European Union and what may emerge as a growing trend toward and acceptance of the criminalisation of European cartel enforcement. And the book addresses a number of key questions on the issue of enforcement objectives. Should those who engineer cartels be imprisoned? In other words, should antitrust activity be criminalised? And that, of course, is the issue. And who exactly should suffer the consequences of antitrust activity? Should it be the companies or the individuals within them who should be held responsible for creating a cartel? And I think, again, jurisprudentially, the law has shifted quite substantially in the last few decades, looking very much more at the individual. And I think, again, that's something that comes out of this book. The moment in Europe, civil punishments for antitrust activities are strictly applied in the form usually of stiff fines, but no criminal sanctions are as yet in place. And on this point, the author reminds us that cartel activity within Europe is prohibited under European Union law by virtue of Article 10(1) of the Treaty on the Functioning of the European Union, TIFU, the text of which is reproduced in an annex to this book, and I've shown you that at the back of the book. The debate apparently rages among legislators, antitrust officials and academics as to the necessity and the appropriateness of personal criminal sanctions, and that's the issue. And that's against individuals, that is, rather than against the companies with which they are employed. It would seem that to date, of course, no consensus has been reached. Nevertheless, there's observably an increasing tendency in favour of criminalising cartel activity within the member states of the European Union. And I have to say that I think that will happen at some stage. It will take time, but there has been a huge overhaul of Interpol, a huge change in the way we do things, and that is going to continue whether Britain remains in the EU or not. And I'm sure personally that they will remain in, and we're just going through a little bit of an argument phase at the moment. Whelan has therefore set himself the formidable task of addressing and examining what he refers to as the theoretical, legal and practical challenges of European antitrust criminalisation, which he stresses should be examined and analysed not separately but as a dynamic whole. The book is logically organised into 3 parts, each dealing with these challenges in turn, before concluding that as interest grows and discussions continue on the thorny problems inherent in establishing a coherent policy on cartel enforcement in Europe, cultural sensitivities, human rights issues and the like being taken into account, the debate in this entire area will continue, and so must the research, of course. Speaking of research, the book presents a 43-page bibliography which opens up any number of avenues of further inquiry and research, and I thank him for that because that's a great bonus with the book. There are also extensive tables of cases and statutory instruments, etc., as well as the 3 annexes and a very useful index. Whelan has certainly shed much light on a complex, often awkward and continually evolving subject, which is also fraught, of course, with implications for corporate responsibility in general. Lawyers as well as academics, we think, and policymakers as well, will welcome the important contribution made by this book to the ongoing debate on cartels within the EU itself. And the publication date, as I indicated, is cited at 2014, and I've recorded this in early May 2015. Let's just have a quick look at the book again. There it is, there's the front, it's hardback, there's the spine and the back there. Just opening it up, just remind you that the index at the back, there it is. Then a lot of bibliography, huge amount of stuff there. And then just open it up right in the middle. The challenge of legal certainty, and the concept of a criminal antitrust offence. There we go, right in the middle. You see, the debate is raging at the moment, and it's going to continue to go. For instance, there's an interesting point here again, the challenge of retribution theory, examining the moral content again, that it really gets back to the very basic points that I make about the fact that there are a large number of people who just don't see this as anything to do with the criminal system at all. There are the contents, you can see them generally, and as I say, I think it's a very good book, one that I'm sure a lot of people will find of great help. The Oxford series in European Union law, which is there, is actually a very important series, and I'm delighted to be able to review this book. Thank you to everybody who's been involved in this. I think it's an important contribution to the continuing debate, and I'm very grateful to have had the opportunity to read this book and to get some idea for myself as to where we're going. Thank you very much. Bye-bye.